The dispute in the case arose in 1795 when the Georgia legislature granted some 35 million acres of state land involving vast tracts around the Yazoo River in what is now Alabama and Mississippi to private speculators for the bargain price of 1.5 cents per acre.
It was soon discovered that all but one of the legislators who voted for the grant had been bribed. In 1796, a new state legislature repealed the fraudulent grant. In 1800, John Peck purchased some land that was part of the 1795 grant, and in 1803, he sold 13,000 acres of it to Robert Fletcher for around $3,000.
When Fletcher discovered the sale of the land had been voided by state law, however, he brought suit against Peck for damages, claiming Peck had lied to him and promising he had good title to the land. The Federal Circuit Court ruled for Peck, and Fletcher appealed to the U.S. Supreme Court. The question before the court was whether the Act of 1796 was a violation of Article 1, Section 10 of the Constitution.
In other words, once the state of Georgia had finalized the original sale of the land, it could constitutionally repeal that sale, or whether the Constitution prohibited it from doing so. The court reasoned that Peck was an innocent third party who had entered into 2 valid contracts. First, when he paid for the land from the original guarantee, and second, when he sold the land to Fletcher. Peck thus fell outside the original fraud the Georgia legislature sought to undo in its repeal.
The Supreme Court, in a 4-1 decision written by Chief Justice John Marshall, ruled that Georgia had violated the contract clause of the Constitution when it repealed the grants. The court conceded that the fraud underlying the grants was deplorable, but it rejected Fletcher's argument that Georgia had the sovereign power as the agent of the people to repeal this act of public corruption. When a law is in its nature a contract, and absolute rights have vested under that contract, a repeal of the law cannot divest those rights. Fletcher's suit against Peck was dismissed, and Georgia's law repealing the grants was struck down.
Whether a law be void for its repugnance to the Constitution is, at all times, a question of much delicacy, which ought seldom, if ever, to be decided in the affirmative in doubtful case. But it is not on slight implication and vague conjecture that the legislature is to be pronounced to have transcended its powers, and its acts to be considered as void. The opposition between the Constitution and the law should be such that the judge feels a clear and a strong conviction of their incompatibility with each other. The court's strict interpretation of the contract clause was modified 17 years later by the Taney Court in Charles River Bridge v. Warren Bridge. But for nearly a century, the decision served as a major barrier to state economic regulation of business corporations.
In Home Building and Loan Association versus Blaisdell, as a response to the massive economic dislocation of the Great Depression, the court ruled that the state could constitutionally alter the terms of any contract so long as the alteration is rationally related to protecting the public's welfare.
The main impact remains to this day that the Supreme Court can invalidate a state action that conflicts with the Constitution. Go Rocks, take state.
Fletcher v. Peck.